All right, we are live and on the record. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justice of the Massachusetts Appeals Court, now sitting virtually within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning. I am Justice Meade, sitting as single justice today, and the case is 21J121, Barroso versus Galarza. What I'm going to do, I'm going to let Ms. Galarza go first, and you can tell me, we're focusing on what are your non-frivolous defenses to the eviction for the summary process bond. So why don't you go ahead and tell me what you'd like me to know.
Okay. Can we just clarify, and I'm sorry, I don't know the proper terms. This is to discuss why I'd like to waive the bond?
Yes.
Is that what we're discussing?
Yes.
Okay. So I had requested that the bond get waived because of financial hardship. I did supply an affidavit of indigency. And again, I do have a financial hardship, and I don't feel that I'm wrong in this case, and it's a burden to come up with that. I have some of it, but unfortunately, my car broke down 3 times with a transmission. I had to pay for a new transmission only to have to get another vehicle because the car broke down again and has to go back to the repair shop. So I live check to check. When this housing matter started, I was on Social Security disability insurance due to an anxiety matter that I am receiving care for. And I had asked the courts to please waive the bond amount because of financial hardship.
Okay.
I have a business.
Well,
I have children.
I'll assume that you're indigent for the purposes of the hearing, but you also have to tell us what defenses that you have, legal defenses in the eviction matter.
Oh, I didn't know we were talking about that too. Okay, so online I submitted some documents, and those documents that I submitted were some of my very serious points as to why I felt that the appeal was necessary for the eviction decision that was granted by the other courts. I supplied documentation. I even raised the claim of perjury and provided timestamps to show that the plaintiffs were not telling the truth in their testimony. I gave supporting documents that were originally submitted by the plaintiffs that backed up the fact that they were not being truthful. And I feel like this eviction was awarded to the plaintiffs unjustly under the grounds that they provided false testimony during trial, which is a trial by ambush, and it did not allow me to properly conduct myself during trial or receive the proper fair hearing that I should have received.
Now, you submitted to us a thumb drive.
And I did supply some.
I'm sorry. You submitted to this court a thumb drive with documents. Let me finish. With several documents that don't seem to be relevant at all to this case, and I wanted to know which of those documents that you submitted were admitted at trial.
So the thumb drive I sent after I uploaded everything on the website, and the one that, and I had called in and asked to discard that, and I had asked how and they told me we're only dealing with the appeal bond matter. We're not dealing with the eviction appeal process. The documents that I uploaded were documents submitted to the courts, and I'm pulling it up myself, and I'm sorry I'm not properly prepared. This is completely embarrassing.
You're doing fine. The appeal bond waiver request has 2 issues: indigency, okay, and non-frivolous defenses to the eviction. So we're going to assume that you're indigent, but I need you to focus on what your defenses are. You've claimed retaliation, you've claimed an ambush, you've claimed perjury, and I just wanted to make sure I understood which documents on the thumb drive were submitted to the trial court and which were submitted after or for the first time here.
So the thumb drive, I dumped everything on there because I wasn't I didn't know what to give and what not to give, but everything supplied on that thumb drive, except for the Excel spreadsheets for my notes from the hearings, are all court-related documents that were submitted. I'm under the impression of, and I'm sorry that I didn't keep a copy of the thumb drive to go over the contents. But everything that I have is stuff that we discussed and was provided to the courts through discovery and through the motions that I have previously filed.
Okay, you've claimed perjury.
Yes.
Was that a claim you made to Judge Michaud?
That's a claim I made to both judges, Salvina and Michaud. And actually the February 24th hearing, when we were discussing the document for the bonds, which I did not receive service on, I gave him timestamps that calls out perjury, and I told him where he can find the documentation. So the first perjury that I mentioned was December 3rd, 2020 at 3:53:22 p.m. Question 7 of the discovery packet was answered by Katrina and Christopher Barroso regarding the inspection, which is relevant because it shows that they were made aware of issues within the unit, and they did not address it when they were aware of it. They didn't address it until rent started being withheld. That was the door frame. And then during their testimony, Ms. Pimentel informed the court that the problem wasn't the door frame, it was the locks. But then there was a text message provided by the plaintiffs that showed that she voluntarily provided that extra lock. And that in fact, my complaint was the door frame. And the door frame was an issue because anybody could walk right into my apartment. It didn't matter if you had a key or not. The door frame was completely removed from the molding was completely separated from the door frame. They noticed the damages, and during that inspection, I believe it was February of 2019, and they didn't repair it until June, July. I'm sorry, I don't have all the documents in front of me, but those documents were supplied in the file that I uploaded to the courthouse when I filed my response.
Could you clarify for me exactly what the perjury is that you're alleging?
So, yep. First time sworn under oath. Counsel for the plaintiff, Maria. So the first perjury that I am will be dishonest, lack of integrity. Testimony began, occupational, denies building relationship, often. Okay. So the first perjury that took place was on December the 3rd, 2020. That's the first time that I noticed the perjury. And again, that was written in their discovery packet. They provided inaccurate information as far as when they did the inspection, if any inspections, and what issues were in the apartment that breached my right to quiet enjoyment and habitability, warranty of habitability, I believe. And that was 12/3/2020 at 3:53:22 p.m. Question 7 of the discovery was answered on page 4. Exhibit E shows the inspection did take place, unlike her response under discovery question 7. The next time that I got a note for perjury was response counsel. Okay, this is the part with the retaliatory trial by ambush, claims text, never noted issues. Okay, on 12/22 at 11:02:25 a.m., Katrina, I'm sorry, this is the attorney. He claims the tenant never noted any issues within the apartment, never indicated any issues with the apartment until after my eviction process. However, again, that was shown to be untrue according to the voided lease that I did submit in my exhibits that was allowed, and testimony.
I'm sorry,
and then the next.
Can I just ask, did you ask them about this at trial?
Yes, I did raise the perjury complaints to both judges, and I can give you the timestamp for that.
What did, if you need that. But the judge made a credibility determination.
Yes. So this was after I was made aware of the bond. So I didn't know about the determination until afterwards. And that's when I called to follow up because there was an issue with the mail not coming to me, even though I provided my PO box with my answer to the summary process. And I had gone to the hearing with them on 2/28/21. And I did bring to the judge's attention that there was perjury claims. He took a note of it and he told me that he would review and get back to me.
Okay.
I didn't hear anything back from anybody.
You said that certain evidence was excluded at trial, like for example, your response to the notice to quit. Did you attempt
Yes.
to enter that in evidence at trial or after
Yes,
judgment entered? I'm sorry,
before judgment was entered. Sorry.
Okay.
I mentioned it to the judge more than once.
And the judge wouldn't take it. All right, tell me about the conditions. In December 2019 and January 20, there was a heating problem, right?
I've had a heating problem for the first 3 years living in the property. And I know I'm just going to briefly run through it so you can understand how it falls on the responsibility of the plaintiffs. When I first moved in, it was a cracked heat exchanger, carbon boiler, black smoke. No problem. They said we can do a temporary fix, but you need to replace it. Then to the following winter, they waited until I received an oil delivery to call me and notify me that the heating facilities needed to be replaced from the previous winter and that I had to wait. Then that repair, which was in fact done by it was done by Christopher Barroso and another gentleman who he's claiming was Royal Flush. And I went downstairs to do laundry and I witnessed with my own eyes Mr. Barroso working on the installation together with that gentleman, which was denied in the court trial. And the insufficient repairs from that situation is what led to the no heat issue in 2019. Because of the insufficient repairs, I was denied an oil delivery.
What was the temperature in your apartment?
12 degrees. 12 degrees outside. My apartment was so cold that I was sick, my son was sick, my daughter was sick. And
what was the temperature? What was the temperature inside your apartment?
It was all the way down on the thermostat. So like where the 65 was, all the way down. It couldn't go any lower. And I did screenshot the web page, which was denied by the judge from the lower court, that shows the conditions outside during the time that I had no heat. And I had the text messages that show they did not give me temporary normal heat until after the temperature started to come back up. And that was around December the 19th.
And this is why you withheld the rent?
Absolutely. I went 3 years without, not just that. I went 3 years in a row with no heat, causing me to need electrical heaters. My electric bill was out of control. I had called St. Vincent's de Paul for help, who informed me to withhold rent and seek counsel to decide how much I should deduct from my rent to help me pay the bill. And I informed them to Katrina verbally. I supported that again in text messages, which was supplied to the courts and allowed as joint exhibits, where I told her, I just gave up my job. I'm on Social Security disability due to very bad anxiety. They don't pay you the minute you go on to Social Security disability. There's a time frame where you go without any income. I had just started getting my checks. I said to her in writing, Katrina, I just got the check. I've got to go through my bills. I've got to make sure that I can I've got to figure it out, right? And she goes, yeah, we're doing the same thing. There's programs for all that stuff. They denied, I've got to show them that I have a real need for the help. according to them. And when I asked them for help, they told me that it was illegal for me to be in the conditions that I was. And I said that to her verbally. I said, I'm not looking for problems. I'm reaching out to Southeast Housing Court for guidance on how to handle this. So that way I'm fair to both of us. And that was provided in a text message. Then she goes from, yeah, we'll discuss, to we never discuss. So then I went into the courthouse to ask for more help. And then I let her know what I was doing. And then I was going through a home study process to adopt my 3 little cousins out of DCF. And they had no GFI outlets in my kitchen. My oven, the vent above the oven has been broken, which was on the list from the walkthrough. And my bathroom was not up to code because of the tub. Was disgusting. So City Hall had to come down and force them to change my outlets. And I do have text messages where she's refusing to even discuss the outlets. She's like, oh, whoa, there's nothing wrong with your outlets. And this is in writing and allowed by a joint exhibit in our trial. So she's refusing and she gets hostile.
I think I understand that. I have one more question. You raise in your papers that you had an issue regarding being served with papers. Can you explain how you were harmed by that service problem?
So, well, I missed very important dates. Apparently, they had appeal bond decisions, and the decision for the evictions was taking place, and the mail was going to my home address. Now, my first document that I ever submitted to the courts, which was my answer to the summary process eviction, I'm sorry if I said that wrong, in my signature, it clearly indicates that my physical address is 433 Oak Grove Avenue, and my mailing address is P.O. Box 9161. And I confirmed before I even delivered that documents to the courts that my mailing address was a P.O. box because I was having issues getting my mail. Upstairs, being your plaintiffs, would sometimes get my mail, and I would sometimes get it. And then sometimes I'd hear about bills that never got delivered to me. So I intentionally went to the local P.O. box and opened up a box after moving there so that when my mail was not coming to me. And yes, I didn't get anything about any of the decisions, the bonds, nothing. And how that affected me, I don't know. I have anxiety. Do you know what it's like to find out after the fact that there was court hearings that you didn't even know about, nor were you served? Then I get a notice from Mr. Espinoza saying that he's dismissing or requesting to dismiss my appeal request because I didn't pay a bond that he didn't even know the figure to when we had our last hearing. He didn't even have a figure for me. How do I know what amount I'm supposed to be paying if nobody's giving me any documents? Yeah, that causes emotional duress. That causes serious anxiety to the point where I had to walk out of my job, okay? Like, I have very bad anxiety. So when I'm hearing that I'm going through something because I didn't pay something that nobody put me on notice I needed to pay, nor did they provide me a dollar amount to pay, that's extremely upsetting. That is going to cause emotional duress. Never mind the fact that I've got to walk on eggshells in my home, argue with my kids in my home about being quiet and respectful. You know, I send them outside to the car so they don't interrupt the quiet enjoyment of the baby upstairs. Meanwhile, I'm getting text messages from the plaintiff current to date talking all kinds of nonsense to me about stuff that it's like, you can't have a dog in your house and you can't have family in your house. It's like, what are you talking about? I've dog sat the same dog before with your permission. And now all of a sudden, she's like, well, due to the current decision in the courts, you can't do that. So you can't take away the things that I've already been doing just because of the decision of the courts. There's no documentations that says I'm restricted. Do you see what I'm saying? It's like that emotional duress is the damages.
I understand. Okay, I think we'll hear from Mr. Espinoza now.
Thank you, Justice Meade. I think just in terms of addressing the most recent accusation or allegation from Ms. Galarza relative to a motion that I had filed with the court relative to a bond amount, it was simply, Your Honor, it was the appeal bond order that we had received as plaintiff's counsel that suggested or ruled or ordered that if the defendant, Ms. Galarza, did not pay the appeal bond within a specific period of time, in order for us to dismiss the appeal, we had to file a motion to dismiss the appeal bond. So we were really just following the order of the trial court judge. I think it came to light subsequent to that in a hearing that there had been some miscommunication between Ms. Galarza and the housing court as to whether or not she in fact had received that specific order, because in the interim, she had changed, I believe, Your Honor, she had changed her address. She went to the court and said, I can no longer get mail at the address that I'm living at, but I need to get it at a PO box or something along those lines. But I'm not sure why that particular issue has any relevance, except to say that the judge sorted it out at that particular moment and gave her an opportunity and didn't dismiss, obviously the appeal bond hearing. We're at the appeal bond hearing today. Getting really simply to the merits of what I think you were inquiring of Ms. Galarza, my clients had purchased this property in January of 2019. Ms. Galarza alleges that there was a heat issue for 3 years, and that may well be the case, that there had been some particular heat issue with the prior landlord. We had filed a motion in limine before Judge Salvidio, who was not ultimately the trial judge, but was sitting for the motion hearings. And the motion in limine was basically essentially to say that no evidence of anything prior to the purchase date of January 15th, 2019 should come in with regard to issues that she complained.
When did your client learn of the December 19, January 2020 heating problem?
They had learned about it in December. And in fact, they immediately addressed it. They had reached out and inquired to 2 local plumbing places, essentially, one in that Mr. Barroso was aware of and knew of. And the plumbing and heating outfits came out and insisted essentially that, listen, the best way to go at this particular point in time is not to fix the oil system. It's really to do a complete conversion to gas. So they immediately had the company come out, knowing obviously that there was an issue with their not having any heat from Ms. Galarza. They addressed the issue with her. They went out and bought appropriate heaters for the unit from Ms. Galarza. And I think the evidence that the judge looked at, and the reason why he found the way he did, is because Ms. Galarza acknowledges in the text messages to my clients that she was grateful for receiving those heating instruments, that they were great. She wanted to know where they purchased them from, that she was going to purchase some herself, I believe is what the text message said. Never at any point in time in December or January
were the space heaters, were they up to code?
There was no evidence brought into trial, Your Honor, that they were not into code. And I don't pretend to be someone that is so familiar with heating installation and these issues that I could say certainly to this court, they're definitely code, but there was no evidence that they weren't. All the evidence
Can I just pause, Mr. Espinosa? Ms. Galarza, this is my fault. I should have explained this at the beginning. We're going to let Mr. Espinosa speak uninterrupted. Okay, he didn't interrupt you. If you want to say something as a follow-up when he's done, I'll permit you to do that. Okay, but right now it's his turn. Okay, I'm sorry, Mr. Espinosa. Go ahead.
No problem. So all of the evidence that was presented to the trial judge was that those specific space heaters, there were no issues with them. There was no problem
with the space heaters. There, what temperature was the apartment?
I can tell you that Ms. Galarza never indicated in either oral communication to my client or text message, and there's multiple text messages, that there was any issue with the heat in her apartment during the time in which the conversion took place. And that's what made the testimony so credible by my client, because we supplied the court with joint exhibits which were text messages between Ms. Galarza and my client from the time in which the heat had been adjusted. So the end of December, when everything was, the transformation had taken place from oil to gas, all the way to February 13th. At the time, there was not one communication from Ms. Galarza at all that there was any issue with the heat. There was no indication that she was unhappy. The only indication to my client was that she was having difficulty paying the rent because there was a mix-up with a check that was coming from her Social Security Administration, that she has a side business where she does tarot card readings, and she was expecting some monies to be coming in from the tarot cards, but because they were Groupons and not just straight tarot card readings, that she wasn't getting paid some way through those particular things. And when I indicate to the court that there were multiple communications, I'm saying that there were a half dozen to a dozen wherein she continues to indicate reasons why she's not able to pay the rent, but none of it suggests that it's in fact due to a condition in the apartment. And of course, in January and February, the heat had long been fixed. The heat was completely converted at the end of December. So it wasn't until February 13th that the text messages bear out that Ms. Galarza now, when my client is insisting, listen, she was pregnant, 6 months pregnant, my client living in the second floor apartment is insisting, we need the rent money to pay the bills. We can't not pay our bills. Ms. Galarza is correct. She did indicate that there may be programs with PACE or some of the organizations for her to get additional monies, but she needed the rent. It was only then that Ms. Galarza alleged, I'm not even sure she said withholding rent, but alleged, hey, I've got all these issues with the apartment. So I think, that's the issue that the judge, I think, looked at in terms of credibility and looking at whether or not she was making a credible claim for withholding rent. And I think, the judge was obviously correct in his decision, at least based on the evidence that was submitted. It was only later. I'm sorry, you have a question, Your Honor?
I did, but I didn't want to cut you off. Finish your thought.
I was only going to just say it was only later that I heard about, the perjury issue, which I can address. I'm not really sure what the particulars of that are. She mentioned it at the appeal bond hearing. But I don't.
Did Judge Michaud make any findings on the perjury claim?
He made findings in the appeal bond order relative to the perjury claim. He had indicated that Ms. Galarza stated that the plaintiffs had perjured themselves during the trial, but she was unable to articulate how the alleged perjury impacted the substantive aspects of the judgment or the decision-making process.
She does claim the eviction was retaliatory. What did you offer to rebut that?
Right. So I think, with regard to the retaliation claim, and if I have it correct, Your Honor, Mass General Laws 239, 2A, and Chapter 186, 18, a tenant is entitled to a presumption that retaliation has occurred, as Your Honor knows, if within 6 months after a tenant exercises statutory right, the landlord commences an eviction action against the tenant. The presumption, as you're, I think, inquiring about, may be rebutted by clear and convincing evidence that such action was not in retaliation. And in this particular case, we would suggest, Your Honor, that the plaintiffs had independent justification for serving the 14-day notice, would have taken the same action if the defendant had not engaged in a statutorily protected activity. And that is, my client's sole reason for serving the notice to quit was because the defendant failed to pay rent for December and January. And even if my clients had not, there was a particular City of Fall River inspection report that came out later in February. But the defendant's failure to pay rent preceded the alleged reason for withholding. So December 1st, there was still heat in the apartment. There's no allegation from Ms. Galarza that there was no heat, I believe, in December 1st, and she didn't pay December 1st rent. So it precedes the actual reason for her to withhold. So there's no basis. Likewise, the defendant presented no proof that she had a basis for withholding January's rent. She, in fact, made representations throughout January and February that she would pay the December and January rent. All along, she continued to maintain, I'm paying the rent. I'm going to pay it. I'm going to make a double payment when she didn't make December's and it got into January. She just never paid it. So my clients, we would suggest, Your Honor, certainly had independent justification for serving the 14-day notice.
Is there anything else you want to tell us, Attorney Espinola?
I think the only thing that I would say in closing is the folks that I represent, Ms. Pimentel and Ms. Barroso, are regular, hardworking, blue collar people that are doing their best to make their way with the American dream of owning a home. They bought this home in January of 2019. It's not as if I think they bought it with the intention of renting it and having a place of their own, but needing, the income as well. And that's why they bought a multifamily property. And I think they did everything right. Anytime that there was any issue that was complained about, they did everything they thought was the right thing to do. And there was no malfeasance on their part, certainly no malintent on their part. And I think that the court should recognize that and award them possession of their property. Thank you, Your Honor.
Thank you. Ms. Galarza, I'm going to let you respond. I ask you to make it brief and with an effort at not repeating things you said in your opening argument. So go ahead.
So I'm sorry, Judge. I just found the document that I submitted to you, and I'd like to respond to some of the statements that Mr. Espinoza had made in his statement just now. Am I allowed that?
Yeah, but briefly.
Okay. So the mailing part we've already addressed, so I'm going to skip that. And then the issue that I had raised to you guys before, as far as the heating goes, right? The heating systems, the propane heating that the plaintiffs had supplied. Now, he's claiming that I never informed them of any issues, right? But in my complaint, I called out reckless endangerment because of those heaters, and the supporting documents that I submitted to the courts in my packet that was mailed to you with that flash drive were labeled I3-supporting documents. Page 1 through 8 are the pages of the docket report up until March 16th, 2021. 9 through 19 are the pages from packet 44 that shows that I did inform the courts of the correct address on my first submission to them, which I shouldn't have had to do again the second time. But the point here is the plaintiff's claims they were never informed of bad conditions, although some of the complaints are listed on the plaintiff's signed lease agreement, although never executed. Appellant also notified counsel for the plaintiffs prior to their filing of the summary process in response to their 14-day notice to quit that this document was present to the court for admission as a joint exhibit since the 14-day trial day notice was allowed. Courts denied the exhibit on 12/22 at 10:56:20 a.m. and again the same day at 11:05:45 a.m. Even though the plaintiffs received a copy March 10th. So they claimed an attempt of trial of ambush by me trying to submit a document that clearly indicates to Mr. Espinoza that I was not withholding the rent for just because I can't afford my rent. But in fact, I was withholding the rent due to the fact that we have text messages that say we need to discuss this. And we never discussed it. Can I ask you this?
Did you send text messages indicating that you were pleased or satisfied with the space heaters?
Well, I'm getting to that right now, but I sent those text messages the same day I received the heater. So this is before I even had a chance to experience the heater. Not to mention those same text messages clearly show where Mrs. Pimentel says, I've thoroughly investigated the use and the safety of all of this. So you can use this at whatever setting you want. The safety features are great. Meanwhile, right before I handed it back to her, before my heat was restored, I found out that it was leaking propane, and that's a common issue with these heaters. And the user manual, which I got off the internet, not from the plaintiffs, clearly indicates not to use those heaters on a setting higher than low in a bedroom or area the same size as a bedroom. And even at that area needed to be properly ventilated. Otherwise, it can result in serious injury, including death. And I submitted those documents to the courthouse as well in my exhibits, which was denied by the judge. So yes, I did complain about the conditions of those heaters before my heat was restored, and I can support that with plaintiff supplied text messages dated January the 19th. And again, temperatures dropped to the 12 degrees outside. I had already given them back the heat. And if I hadn't already given them back the heaters, why did they have to pour diesel fuel into the oil tank, which was deemed unsafe by my local delivery guy and their repair guys? And then afterwards sends me another text message saying that the conversion was all set and that I have normal heat now. And that is all also supported by plaintiff's supplied documentation as far as when they placed the order for parts for the oil conversion to gas, when they were able to pick up the parts for that. And it shows right there, if you look at the dates and the timestamps on their receipts, the text messages, it clearly indicates that I clearly gave you back the space heaters. If you had to pour diesel and send me a text message telling me that I could use the heating system temporarily, and then you send me another text message saying that the conversion was all set and that I had normal heat again. So if I never returned those propane heaters due to verbal complaints to the plaintiffs, why did they stop using those heaters, pour diesel fuel into the unsafe oil system, and then send me another text message telling me that the conversion was all set and that I can use my heat like in a safe manner? So
Okay.
his statement right there is inaccurate.
I think I understand.
And in the paperwork I sent you too, the false testimony, right? The return receipt of leftover items, plaintiff provides false testimony on 12/22/20 at 12:46:43 p.m. that the appellant was complaining of inadequate locks, but also provides a text message from the plaintiff to the appellant noting that she took the initiative to purchase the locks on her own as the plaintiff exhibit C, page 1, fourth message down, which is providing false testimony in order to avoid the plaintiffs from taking responsibility for violating the Massachusetts State Sanitary Code 410.480. Plaintiffs also misinformed the courts by stating they hired plaintiff Christopher Barroso's employer to handle the replacement of the oil burning during the winter of 2018 on 12/3/20 at 3:58:50. Plaintiff supplied a signed document from the former owner in their motion in limine, Maria Pimentel, which is also the mother of plaintiff Katrina Pimentel, as supporting document with the deed while presenting their motion on 12/3/2020 at 3:28:11 p.m. Ms. Pimentel was not made available for questioning, although because I only had a phone number for Mr. Barroso's employer, who is the alleged company who installed that new boiler in 2018, he said, I can't give you anything in writing because I never did that. My company is not responsible for that. We were never hired, but here's my personal cell phone number. I provided that to the judge in the lower court. He denied me the opportunity to have that gentleman called for testimony, for verbal testimony. And I was told by the clerks that if you have any witnesses, they need to be ready and have a phone number. How am I supposed to go and interrupt this guy and pull him from his job? He's sitting there saying, here's my personal number. I'm the boss of the plaintiff. And I'm saying my company never installed that oil burner that they're claiming we did in 2018, which was done inadequately and resulted in the bad conditions in 2019, which is why Mr. Barroso should be held accountable. He got through that motion in limine for providing false testimony. Plaintiffs are, so they're related to the former owner, they're related to the company that allegedly did the repair, but yet they could not supply any proof that they ever hired anybody, paid anybody for anything. If anything, the documentations that were available show that they paid for it themselves. No permits were pulled at any time for any of the repairs since Mr. Barroso and Mrs. Pimentel have owned that house. Not one permit, not for the outlets, not for the electrical work, because my electricity was tied to the common areas, which I never put in my report because I wasn't trying to be frivolous. Is that the word? There's so much more, right? So my other thing that I wanted to address with Mr. Espinosa's, Ms. Pimentel denied the appellant the right to pursue her claim for bad conditions, breach of warranty, quiet enjoyment, and damages for 3 consecutive years of failure to properly maintain the heating appliances. Plaintiffs handled the repairs of the oil burner during the winter of 2018 due to the unlicensed repair they alleged was completed by Royal Flush, right? It was on December the 19th, 2020, that external temperatures were as low as 12 degrees. Web page confirming outside temperatures under Appellant's Exhibit B was presented and denied on 12/22/20 at 1:22:14. Additional supporting documents is a witness statement from Charlie's Oil under Appellant's Exhibit A. Appellant raised the claim of perjury again during cross-examination on 12/22/20 at 11:37:28. Plaintiff Katrina Pimentel informed the court she provided 3 DeWalt heaters for a family of 3 in a 3-bedroom double parlor home to aid during 12-degree external temperatures. Appellant's claim of bad conditions and breach of warranty and quiet enjoyment was violated due to insufficient heating for the family of 3 in the large apartment, because I only got 2, and also lacks sufficient insulation. Plaintiff supplied 2 of those heaters, and this new information conflicted with the plaintiff's provided text messages under Defendant's Exhibit C, pages 1 through 5. It also conflicts with the appellant's response to the 14-day notice to quit that was denied denied entry by the judge in order to avoid a trial by ambush on 12/22/20 at 10:56:20 a.m. and again at 11:05:45 a.m. This should not have been considered an attempt of trial by ambush, since the attached to the response was the date stamp of the email that shows the plaintiffs received the document calling out bad conditions and that I was withholding the monies in an attempt to resolve matters prior to the summary process being filed in the courts on March 10th, 2020.
Okay,
The relevant...
we have your papers. Okay,
Oh.
so you don't have to read them to us.
Oh, okay. I'm sorry.
So,
because of my
no,
anxiety, I have to read things
I
because my
understand
mind goes blank.
you're doing fine, and I understand the issues, and I'm gonna take this under advisement. Okay, and I'll have a decision as soon as I can.
Thank you, Your Honor.
Well, thank you both.
Thank you.
Is KG there?
I